Okay, so this is the case of Lloyd and Google LLC 2021. This is a UK Supreme Court case. A very important, very, I'd say, in the modern times, one of the most important cases for data privacy. Yes, so the introduction is that it has a potential of having a significant impact on the data privacy rules and how other cases may also be considered in UK. This case, the judgment of this case talks about other rulings as well. So it's better to read the entire case and then watch this video, or just watch this video, then read the entire case and understand what the judgment is truly about. So we'll just go over, this is a very short video, so it'll just go over small facts and details of this case. Very brief facts and very brief of the ruling, and then end. So this is just a quick summary, 3-4 minute summary for the entire case. So we have Mr. Richard Lloyd, who had issued a claim against Google LLC for alleging a breach of its duty as a data controller. We know what Google is. Google is a data controller. And the breach was under the section of 4, subsection 4 of the Data Protection Act 1998. So one of the most important questions that I have seen, it is that why 1998 is, the reason for that is because it's in the years of 2011 and 2012. So the applicable legislation at the time was the DPA 1998, not the 2018 one. That is not applicable. Sure, you could still read and construe stuff, but still, the 1998 DPA would be applying here. The claim alleges that Google secretly tracked the internet activity of millions of Apple iPhone users and used the data collected in this way for commercial purposes without the user's knowledge or consent. Okay, this, though it's not a novel situation, because yes, there has been cases where people have brought actions against Google for data privacy, for collection of their data, but now there is a aspect in this, which is there is an aspect in this, which is that Mr. Richard Lloyd claims to represent everyone that is the resident in England and Wales who owned an Apple iPhone at that relevant time and whose data were obtained by Google without their consent, and to be entitled to recover damages on behalf of all of these people. So the estimated number of people is 4 million, and the estimated amount is £3 billion. One may argue that £3 million may not be that much for Google, because Google might make £150 billion or more in a year. But then again, it's still a very large sum. Nonetheless, it's a very large sum. And also the idea is this element is very important, that the activity that was tracked down for the users without their consent or knowledge, there has to be some sort of damage. So there are some paragraphs that I'd be reading which are very good. Yeah, so the way we see it is the fact that what is new about the present action is that Mr. Lloyd is not just claiming damages in his own right. He claims to represent everyone resident in England and Wales who own an Apple iPhone, right? And so for this, it's a class action in which a single person is permitted to bring a claim and obtain redress on behalf of a class of people who have been affected in a similar way by alleged wrongdoing. So this has been long-standingly possible in US, in Canada and Australia, recently in Canada and Australia. Okay, so the judgment also goes through different types of actions. So this is a class action, then representation, and others as well. So Google on this application contested, of course, on the grounds they were saying that the claim has no real prospect of success, as the first ground was damages cannot be awarded under DPA 1998 for loss of control of data without proof that it caused financial damage or distress. And second, the claim in any event is not suitable to proceed as a representative action. So these are two claims. The first one is actually very legitimate because every single person, like all the 4 million people, need to somehow prove that they suffered a financial damage or distress, which is impossible. Okay, so that is impossible for 4 million people to still be there and um, or more people to still be there and say that, okay, we did suffer this damage, this financial damage, or this distress because of what Google did. Now, there's this one paragraph I'd like to read, that is paragraph 23, I think. And it talks about individual claims because the judgment is littered with other judgments as well. And it does talk about there are judgments as well where claimants have been more than 100,000 and 10,000 claimants have actually appeared in court. Like they've actually signed the papers and they've been like, okay, we are willing to become a part of this claim. And similarly, there has been another case mentioned in the judgment where there were nearly 1 million claimants, but only hundreds came. So you see the difference. So for 4 million claimants, how many would actually appear in court? Now that is also an important, relevant thing to consider. Well, so the court does say that there is no doubt that the claimant is entitled to advance a claim against Google on this basis in his own right, which has a real prospect of success. The issue is whether he can do so on behalf of all other iPhone users who fall within the representative class. Now, that is one of the most important aspects because of this reason, um, and that no, at large, no people can prove that they actually did suffer a loss. If they could, and only then they would be allowed to claim, but because they couldn't, so the claim fails. So we have the last paragraph. So it was that the foundation, the damages cannot be claimed because of the reason that representative claimants should not be permitted to consume substantial resources in the pursuit of litigation on behalf of others who have little to gain from it and have not authorized the pursuit of the claim nor indicated any concern about the matters to be litigated. So they take this from the early judgment, and this, seems to sum it up how the courts view this. Yeah, so the legal issue is that Mr. Lloyd contends that the Google processed personal data of each member of the representative class. Okay, so he did mention that there was the first, second, and the seventh data protection principles that were violated. So in the factual background, you'd see that Google had a cookie known as double-click ad cookie, which could operate as a third-party cookie. It would be placed on a device if the user visited a website that included the double-click ad cookie, and so that information would be stored and given to Google, and then they would sell it to the advertisers and in the commercial market to whom the advertisements would be, given to the consumers. So if you're searching for something like a drink that you wish to drink, and then you searched for it, and if that cookie was placed on that page or if it was on your device, so you will be given those advertisements for the next 2-3 running days if Google has those advertisements on board with them. So that was the personal, privacy invasion. Yeah, so we've all okay. So the important aspect in this is that so the claim has been framed in order to try and bring it as a representative action. The claimant seeks damages under Section 13 of the DPA 1998 for each individual member of the represented class without attempting to show that any wrongful use was made by Google of personal data relating to the individual, or that the individual suffered any material damage or distress as a result of breach of the requirements of the Act by Google. For the reasons explained in this judgment, without proof of these matters, a claim for damages cannot succeed. So I think that is genuinely the most important aspect, that you have to prove that you did suffer distress, damage, or something did go wrong, and only then can you actually succeed with a claim. Um, I would say read the entire judgment, because this is a very, very, very simplification, a very small simplification of the judgment. This is as far as I could go in a few minutes, because this is what I was asked. I hope this was easy enough to understand. It was bite-sized and easy to digest. If you have any further questions, for the 2023 May June examinations, there are three topics. There are three theories to consider. That is Dawkins, liberalism, and a feminist theory. So Dogen, you may consider from the hard cases and the Hercules' perspective and others. I can make a video if you want. You can reach out to me, or comment or something, and I'll make a video according to Dorkin's perspective, because I actually have notes on those. So if there are any other questions, you can leave them, and I'll try to read out the entire judgment as well. Thank you.